Good afternoon, everyone. Good afternoon, everyone. On behalf of GSEHD's leadership, faculty, students, and staff, I'd like to welcome you to our final DEI event of the semester. As GSEHD will welcome Dr. Erika Wilson from UNC Law School, as she will talk to us a little about her paper, Monopolizing Whiteness. My name is Dwayne Kwaysee Wright. And in addition to being a visiting assistant professor here at GSEHD in Higher Education Administration, I also have the distinct privilege and honor of serving as your interim director of Diversity, Equity, and Inclusion Initiatives. And we welcome Professor Wilson today to share her thoughts, her concerns, and quite frankly, her brilliance as she brings us her work in progress paper on this topic. Before we get started, I think it would be remiss to do a diversity event today without mentioning a few words about the verdict in the Derek Chauvin trial. Yesterday, we know that the officer that killed George Floyd was convicted on all counts, and we celebrate that as a community as we hope that a little bit of justice was served to the family. However, we know, and this is an academy and we go with what we know, not our opinion, that justice is not a verdict. It's not one verdict. It can't be. Justice is not a act. Justice is an act against an unjust system. Justice is not a moment. Justice is some moments that make a movement. So while it might seem like a bit of justice for the family, it probably is a little bit more requisite to call it accountability. And we're glad that we saw accountability for George Floyd yesterday. Justice would be more than statements, it would be action. Justice would be George Floyd being alive today. Justice would be the fact that we wouldn't have the funeral of Daunte Wright just a few days after. Justice would be the fact that many of us would not have woken up to the shooting of yet another Black teen this morning who the cops unmistakably or perplexingly thought that they needed to kill, as they say, to protect other children. Here at GSEHD, we are committed to justice and equality, and we continue to practice that commitment. We hope that you take this event as such a small evidence of our commitment here today. With that said, I have the distinct pleasure and honor of welcoming Professor Erika Wilson. As many of you know, in my events, I let the authors introduce themselves, but I must say that one of the distinct pleasures of this job is to have conversations, be in conversation, and present people that, I would say is an intellectual crush. Dr. Wilson's work has been inspiring, not only to me, but to a generation of scholars and activists that are coming after her. And I will say that I would like to join everyone else and congratulate you on behalf of GSEHD and GW, Dr. Wilson, of being recently earning the promotion to full professor, along with the many other titles that you have. For my GSEHD family, I have put Dr. Wilson's faculty page in the chat, along with a integrated schools article on the paper for anyone that failed to do their homework and want to catch up before we talk. Erika Wilson, we welcome you here to GSEHD. So, before we get into the paper, here's a first question for you. Who are you? Tell us a little bit about yourself. Tell us a little bit about your work. How would you describe your research agenda? And how did you get doing what you do?
Well, let me start by saying thank you so much for inviting me here today. And thank you for your words about the George Floyd verdict. I mean, I think it's really important to acknowledge the moment we're in. So I appreciate that. So a little bit about myself. Again, my name is Erika Wilson. I am a law professor at UNC Chapel Hill. And so I'm actually originally from the West Coast. Unusual fact about me is that I grew up in Las Vegas in Nevada. And my parents are originally from the South. My father grew up in Louisiana and my mother in Arkansas. And so The reason I lead with that is because I always like to explain why it is that I write about and research what I research about, which is racial equity or inequity in schools. And so one of the reasons that I write about that is because my family migrated to the West Coast, like many other Black families, in search of better opportunities. But both of my parents grew up in the Jim Crow South. So my students are always perplexed to learn that I am the first generation of my parents' children to go to schools that were not racially segregated by law, to go to schools that were desegregated in some sense. So one of the reasons I write about this is because having the opportunity to go to a racially integrated, higher quality school literally changed the trajectory of my life in terms of opening up opportunities that otherwise wouldn't have been there. And so I think it's really important. I know that reasonable minds can agree or disagree about the painstaking efforts that are undertaking to obtain racial integration or at least desegregation in schools. But from my own personal lived experience, it means something to me deeply. And I think I think if other scholars have said it's one of the solutions that we know actually works in terms of improving test scores, giving students of color, particularly students of color from low income backgrounds, opportunities to go on to higher education, et cetera. And so that is why writing about this issue is really important to me. In addition to writing about this issue, I've actually also litigated school desegregation cases. I was a lawyer for the Lawyers Committee for Civil Rights under law, where we litigated school desegregation cases, and people are always surprised to hear that. Like, oh, Professor Wilson, isn't that over? Nah, it's not over. It's not close to being over. There are many open cases and cases that should be open. So I did a lot of work on that in Georgia and some other southern states. Let's see what else. But in addition to researching and writing about racial inequality in education, I also, I'm a lawyer, I'm a litigator. I run a civil rights clinic where we generally, I say, represent clients who are marginalized, subordinated, and trying to get racial justice equity in a wide range of areas, including education.
No, no, that's fascinating. And a lot of that I didn't even know. So thank you for sharing that. As we move into the meat and potatoes of this discussion, please know that we are taking questions. We will have a Q&A after my conversation with Professor Wilson, but please feel free to utilize the chat. You can put it in there. You can utilize the Q&A function. If you want to send an anonymous message, you can send it to me and I'll keep it anonymous, or you can send it to our Chief of Staff, Meg Holland. Just give her a direct message and we'll be sure to get to those questions momentarily. So Professor Wilson, I'm as a lawyer myself that sits in an education school, I'm always perplexed about, the sort of interdisciplinarity of it, the sort of combination of it. What would you say, if you had to think about it for a second, lawyers have to offer to educational research practice, but also, what do you think educational research practice has to offer to the law?
Yeah, it's a good question. I mean, I think in general, I always like to explain that the law, whether you're talking about the law with respect to education or many other areas, is what sort of structures and organizes the rules of the game, so to speak. So, in the context of education, for example, laws about how we distribute public education, school assignment laws tell us where students are going to go to school. Those laws are typically, as I write about, coincide with where students live. So the law is a very important parameter in terms of dictating educational opportunities. On a more micro level, right, the law determines who, how, when, and why we will provide certain special education services to students diagnosed with disabilities. And so again, I just use that as an example of the ways in which the law dictates the parameters of a lot of what happens in education. And so, from that perspective, I think there needs to be a symbiotic relationship, I would say, between scholars of education and legal scholars. Scholars of education should be offering us insights regarding pedagogy related to the process of learning, the process of teaching that should inform the rules of the game that lawyers ostensibly interpret and enforce. I would say conversely, legal scholars should also be analyzing these laws and rules of the game and hopefully informing education scholars how to operate within those rules. And both education and legal scholars, I think, should coalesce to make sure that we have the best education related practices and laws.
Have there ever been instances in which you've seen that relationship work? Any place you can point to? At GSHED, we're always constantly looking to improve, constantly looking to perform. We try to be at the cutting edge, the vanguard, if you would, of all types of educational research. Any models we can look to better our relationship there?
Um, I think maybe more from a practicing lawyer's perspective, when I think about some of the large scale litigation I've been involved in or I'm aware of in North Carolina, for example, there's the Leandro case. Certainly, we relied heavily on persons with expertise in education pedagogy. Same thing with some of the school desegregation cases that I worked on. So from a lawyering perspective, definitely I think that education scholars have a lot to offer. So I would actually argue maybe in some ways that education scholars are particularly well suited to think about how to be effective in these kinds of larger scale litigation cases to offer their expertise. And that in order to, I guess, make that a reality, it would be useful to have that pairing partnership with legal scholars so that there's a clearer understanding of where one's expertise might fit in.
Yeah, yeah. So I'm often reminded that the first time I read your work was when I worked for Dr. Erika Frankenberg at the Center for Education and Civil Rights at Penn State. Also, I worked with Dr. Liliana Garces, and they both tried to implore, not sure they were successful, the evidence and the need for social science within evidence. You are a uniquely positioned scholar to talk about that. So, one more question before we get to the paper. If just in general, could you give me the sort of state of the state with social science evidence, particularly in education, impacting education litigation? Do we need more? Do we need less? Do we need different types? Particularly as a scholar that writes on desegregation, and not just desegregation from the minoritized perspective, but for the benefits of desegregation from white students. Is more social science evidence needed or no?
I would say absolutely more social science evidence is needed. I mean, if you think about seminal cases like Brown versus Board of Education, right? The Supreme Court in that case relied on some social science evidence, but not all of it, as I argued. They left out some important pieces of social science evidence that may have changed the course of how we look at Brown versus Board of Education. But certainly, I think that litigators again could borrow heavily from social science evidence or could use it in terms of being able to fashion arguments, legal arguments to make. I think the one area, at least where I am particularly interested in seeing this happen more, is in teasing out and articulating the role of housing segregation in terms of how it impacts school composition, how it impacts the connections between housing segregation and prior state action, the connection between residential segregation, and things that seem completely off, but police killings of Black people, for example, larger questions of systemic racism, and the ways in which we could use that social science research to make arguments about why it's important to have racially integrated schools and the benefits of creating racially integrated schools.
Okay, I'm going to give you one more opportunity to take a pot shot at education if you want. Do we, schools of education, need to be better at disseminating the evidence that we produce, the good research here at GSHED, over at Penn State and other places? More, I think, when I was purely in law school, if I didn't have that joint degree, I probably wouldn't have read much. Do we need to be better at doing that and getting that to the litigants such as yourself?
Yeah, so I won't completely take a pot shot only at education scholars. I'll take a pot shot at all scholars, okay? On this front, I think we should all be better about disseminating our research and making sure that our research can be put to practical, effective use. It's always that saying, if tree falls in the forest and no one hears it, does it really fall? So I'm without a doubt, I think that all of us as scholars could be better about figuring out how to get our work out there and get our work into the hands, particularly of experts who can put it to use for very practical purposes like litigation.
Yeah, and I will say to the students that may be on the call with us, I won't ask Professor Wilson to put her Twitter out there. I'll leave that up to her if she wants. But if you want a master class on how to use Twitter for scholar activism, Professor Erika Wilson should probably be giving one because she does that par none to anybody. But let's get to the meat and potatoes of the. Could you summarize monopolizing whiteness for us? I know it's not done, but could you just summarize the arguments, particularly for a non-legal audience, if you don't mind?
Sure, absolutely. So I would summarize it like this. I mean, the first thing I would say is that I think even for the average layperson, right, has some familiarity or understanding of racial segregation in schools. And so what monopolizing whiteness does that's somewhat unique is that it looks at this question not from the perspective of students of color, but from the perspective of white students. We often talk about the ways in which schools are increasingly resegregating, for example. And when we talk about racial segregation in schools, the picture we usually have is a school that is predominantly Black or brown. But there's a flip side to this as well. There are schools that are predominantly white and affluent. And so what monopolizing whiteness does is it looks at those scenarios, particularly in racially diverse metropolitan areas where it would be possible to have racially integrated schools. And the reason I specifically focused on racially diverse metropolitan areas is because I wanted to examine the consequences of white students being aggregated together in a space where it would be possible for them not to be. And the reason I wanted to look at that is because I think, again, we often talk about school segregation from a deficit perspective in terms of what students of color are missing. And we don't talk about it from the inverse of that, from the perspective of what white students may be hoarding and some of the harms to white students of not being in racially diverse areas. So in a nutshell, what the paper argues is that white students in some racially diverse metropolitan areas are monopolizing high quality schools. They're doing so by taking advantage of certain structures like housing segregation, wealth inequality that allow them to situate themselves in school districts that are going to be predominantly white and predominantly affluent. And the existence of those districts, those boundary lines, serve as almost a magnet function, inducing the high quality educational inputs that are needed to create high quality schools to locate themselves in that one space, and that this is bad for American democracy because it allows a narrow cohort of folks to hoard the best educational opportunities, and also deprives those white students in particular of the opportunity to learn how to live and interact in a racially diverse world. And we get a lot of negative consequences from that. I think recent events should have shown us the importance of understanding whiteness and thinking about how to make sure that white folks in particular are introduced to a more racially diverse group of people. I did in paper argue that while this is a problem, the doctrine we tend to look to in the law, equal protection doctrine, is not well suited to address this problem for reasons I can go into. And I suggest that because the main harm I articulate of white student segregation is monopolization of high quality schools, that we should look to antitrust law, which has an anti-monopolization framework that we might extrapolate to the problem of white student segregation to figure out how to demonopolize, monopolize white students in racially diverse metropolitan areas.
Wow, wow. Brilliant, brilliant. Very fascinating too. I have so many questions. I want to push back. I want to accept. I want to remind our audience that within the next 20 to 30 minutes, we'll be getting to your questions. So keep them coming. If you wanted them to be anonymous, you can send a DM to myself or Meg Holland. You can utilize the Q&A or the chat function. So the paper is called, let's just start there if you don't mind, Monopolizing Whiteness. And I can see in my mind's eye some of my conservative friends probably getting the invite to this, saying, "What's that?" and coming here just for that word and not hearing anything that you just said. So, let's satisfy them maybe just for 1 second. Can you define whiteness? And I'll tell you what, before you define it for the paper, could you just define whiteness in general, what you mean by that? And then
Yeah.
can you hit me with another one and sort of define it for how we're using it in this particular paper?
Sure. So in general, I would say that I would start even broader and define race. So race is a social construct. It is not biologically determined. What does that mean? There's no gene that makes someone Black or Latinx or um, Asian, but instead, as humans, we created these social categories based on phenotype, let's say for shorthand, and that all the other things that come with these phenotypes are socially constructed. What do I mean? And this is important, particularly for understanding what I mean by whiteness. So, as a lawyer, I think it's especially important to understand that the law played a pivotal role in determining who was white, but it did so by exclusion. So the law defined who was white by determining who was not white. And so this mattered because the law meted out certain property interests to those persons who were raised as white and denied them to others who were not raised as white. Some of the key property interests that it parsed out are freedom, right? People are surprised to know there's a line of cases where individuals would go to court and litigate and argue before a judge that they were white and therefore they shouldn't be enslaved and they should be free. There's a line of cases where people would go to court and argue that they are white and therefore they should be able to immigrate under the Immigration and Naturalization Act. And the court would either say yes or no. And so, why am I telling you this? Because the historical association with being raised as white gave one property interest that you did not receive if you were not raised as white. And so for a long time, these laws existed. I mean, even going back to the New Deal, where the FHA would not lend to areas that were not white, particularly explicitly would not lend to areas deemed Negro. So for a very long time, whiteness picked up property interests. There's literally tangible pieces of property that you got by being raised as white. And so when I talk about whiteness generally, this is what I'm talking about, the social construction of being deemed in the category of people who's white, because there are tangible benefits that come with that, and there are also intangible benefits that come with that. And I think some of the intangible benefits that come with that are certain kinds of credibility, certain kinds of freedom in the way that one walks through the country. I mean, if I've gone into a store as a Black woman and been followed, and would not have had that experience if I were white. I've gone into an ER with the white woman and got a totally different experience than I did when I went by myself. So this is what I mean when I talk about the intangible benefits of being white. So again, for shorthand, when I say whiteness, this is what I'm talking about, the social construction of being placed in this group of people raised as white, and the tangible and intangible benefit that come with that classification. So that's how I would define whiteness.
Wow, the class is in, the class is in. Such a brilliant description. So the next question, and I'll call you or this Dr. Wilson, and they'd say, well, the law degree is not, it's a Juris Doctor. But the reason I'm calling you doctor for this purpose is you use a sociological concept in this paper called social closure as best and even better than I've seen some other actual social science doctors use it. And it was truly amazing. And I had to read it a few times to capture it. Could you describe to us what social closure theory is and how it applies to this paper?
Yeah, and so I'll start even before describing social closure to say the reason that I wanted to look at a sociological theory to understand white student segregation is because when queried, the majority of white parents expressed preference for sending their kids to racially diverse schools. They express a preference or a desire to have their children in racially diverse environments, but their actions belie those statements, right? So if we're taking those statements at face value, there's this paradox. Why do white parents say they value diversity, but act in ways that are contrary to that and create essentially white enclaves in terms of schools and racially diverse metropolitan areas? And so I wanted to look at social closure, which is essentially a sociological concept that explains how society produces and maintains inequality. And so the theory suggests that um, there is always the construction of what it calls an in group and an out group, and the out group is usually constructed based on their otherness, and so things like race and ethnicity are common forms of otherness that are used to mark the out group. The in group usually forms based on some notions of similarity. Again, race and ethnicity can be a marker of similarity. But the key point of the forming of the in group and out group is that to engage in a dynamic process of subordination in which the dominant in group uses exclusionary practices to monopolize scarce resources. So
Mm-hmm.
the end goal of the closure is to monopolize some resource that is scarce, or as I say in the paper, perceived as scarce. And so from a lawyer's perspective, interestingly, the theory suggests that the dominant in-group often takes on a legally privileged status in order to monopolize access to the scarce resource. And that the scarce resource closure exists when there's both scarcity, some mechanisms of exclusion and monopolization. So that's a very rote explanation of social closure.
No, I think I get it. I think I get it. Is that intentional? Is that unintentional? Does it matter?
So social closure would suggest it's intentional, right? That there are exclusionary practices that are put in place intentionally to monopolize the scarce resource. I would argue that it doesn't matter if it's intentional or not, if the end result is the same. But I think it's also important to understand that the exclusionary practices don't have to look like Jim Crow segregation, which is the point I'm trying to make in the paper, that the exclusionary practices can be things like adopting policies with the racially disparate results, practices or cultural norms that will have the tendency to favor the in group and disfavor the out group.
Yeah, yeah. I think of the work of Nicole Hannah-Jones, who visited us earlier this semester here at GW. I think of the work of our own Dr. Joshua Glazer and Dr. Iris Rottenberg that speaks to that as well. And, that is interesting, the way the closure, and that kind of leads to the monopolization. And I want to get there. But before I do, let's stop on equal protection, because the whole purpose of the paper is that there's something that was there at Brown, equal protection, and it's not adequate enough. For a non-legal audience, Dr. Wilson, can you describe to us what the Equal Protection Clause does, what it did for school desegregation and segregation, and why now in 2021, as we are now with school districts that are more segregated than at the time of Brown, it became or is inadequate?
Yeah, so I'll start with the relevant text of the Equal Protection Clause, which essentially says that no state should make or enforce any law um, that abridges the privileges or immunities of citizens of the United States or denies to any person within its jurisdiction the equal protection of the laws. And so the Equal Protection Clause is that last part, nor deny to any person within its jurisdiction the equal protection of the laws. And so the way that we got to undo Jim Crow segregation was through Brown versus Board of Education. In Brown, the Supreme Court examined that equal protection clause that I just read to you and said that segregated schools violates this clause because it denies Black citizens equal protection of the laws. It does so by relegating them to schools that are inferior, schools that have lesser resources, schools that are raced as Black. In and of itself, the court suggested violated that particular law. And so one of the problems with the way the court interpreted the Equal Protection Clause is that they read the using social science research, as I alluded to earlier, they suggested that the social science research said that by aggregating Black kids or combining them into Black schools, it generated a sense of inferiority amongst them, and that when the state actively did that, it violated the Equal Protection Clause, equal protection laws, because the state was intentionally doing it. So the way the equal protection jurisprudence has evolved since Brown has been to require litigants arguing that this clause was violated to show that there was a state actor who intentionally did something to deny them the equal protections of the laws, just as states intentionally put laws on the books that said Black kids go to these schools, white kids go to these schools. And so the Equal Protection Clause worked fine and the interpretation was fine. We're dealing with the express, overt forms of exclusion and discrimination, like a law that says that you have to go to a particular school because of your race. But as I argue in the paper, discrimination adapts. It's no longer culturally, legally acceptable to engage in that kind of express discrimination. So what we see now instead is the adoption of certain policies that will have a racially disparate impact, but from which the intent is to attenuate it, to attribute it to a state actor, which makes it very difficult, if not impossible, to find a violation of the Equal Protection Clause.
So, Professor Wilson, let me just see if I am digesting this. If equal protection of the laws are denied, but it's unintentional, are you saying the Constitution provides no remedy?
If it's unintentional and if there's no state actor, that's exactly right. And so the state actor part also becomes important because in the case of white student segregation, the Supreme Court has essentially said that any segregation that's a result of parental choice, parents choosing to live in a particular area, is beyond the remedial purview of the Constitution and that there's nothing that can be done. So with forms of modern segregation, especially white student segregation, the two impediments I argue to the Equal Protection Clause being useful are this issue of state actor. It's hard to attribute the white student segregation to a state actor under current interpretations of who could be a relevant state actor, and intent. It's hard to show that the state is intentionally creating these segregated conditions. So that is why so many the school desegregation cases that I mentioned I litigated earlier at the Lawyers Committee, that is why we had such a hard time prevailing.
Wow, wow. For anyone that may just be joining us or joined us late, we're here with Professor Erika Wilson from UNC Law School, newly minted full professor, director of clinics, Wade Edwards Distinguished Scholar, more and more praise, and she's describing us her work in progress paper, Monopolizing Whiteness. We're about 15 minutes away from your questions. So please light up the chat, light up the Q&A as I see some questions are coming in already. So Professor Wilson, I think we've got the whiteness part. We've got the inadequacy of the equal protection, no state actor, no intent, nada, which is kind of crazy because most things aren't unintentional now. Why antitrust law? Because, you seem to me as a pretty progressive scholar, right? And progressives are kind of moving away from the corporatization. Why antitrust law?
Yeah, so I want to set out at the front end of the answer to this question is that this is by no means intended to be a neoliberal intervention that suggests that the market is the appropriate way to distribute resources. Instead, actually, the intent using antitrust law was to frame the harm being done particularly by white districts in terms of a market failure for purposes of making an analogy rather than for purposes of suggesting some kind of marketization or neoliberal intervention. And so the reason I chose antitrust law is because it's the one body of law that we have that deals with the problem of monopolization. And so because I am arguing that the harm that occurs when you have white student segregation is monopolization, I wanted to look and see how do we regulate monopolies in other contexts. And the way that we do that is through the Sherman Act. And so I want to make this important distinction is in that I'm not suggesting that one could bring a viable cause of action under the Sherman Act for white student segregation. That's not at all what I'm saying. What I'm saying is that we can analogize to the framework that's present in the antitrust Sherman Act, particularly the Essential Facilities Doctrine, to think through conceptually ways to think about framing the problem of white student segregation and remedying the problem of white student segregation. So for purposes of my analogy, right, I suggest that the Sherman Act is supposed to protect the competitive process that spurs economic growth. And it's undergirded by the notion that competition is vital to a well-functioning economy. So I analogize between the Sherman Act and schools by suggesting that fair, open access to racially integrated, high-quality public schools is to a well-functioning democracy as competition is to a well-functioning economy. So if we see fair access to racially integrated schools as an important part of ensuring a well-functioning democracy, then we should use the framework provided in the Sherman Act same way it's provided to ensure and to protect the competitive process in the context of economic growth. So I turned to a doctrine called the Essential Facilities Doctrine. And the reason I turn to the Essential Facilities Doctrine is because it's the one doctrine in antitrust law that imposes upon competitors a duty to share with other competitors. And it does that when a competitor has access to a facility that is essential for competition, meaning that other people can't compete in the market without access to that facility. And so I'm saying that in this analogy that white students in these districts have access to this essential facility in terms of high quality schools, and that students of color have no reasonable shot of being able to effectively get access to high quality schools without some demonopolization through the application of I won't get into the technicalities of the test here for the non-legal scholars, but through this very technical test to determine whether or not access to an essential facility is being denied in an analogous construct for purposes of schools.
No, and I know we may have some visitors from GW Law. Feel free to contact Professor Wilson to get the nitty gritty, because I had the privilege of a couple of weeks ago getting through the entire paper, and I can say it is fascinating. It really is. It really is. So I want to get to Essential Facilities Doctrine, because I think, you just posted that as something at the heart of the matter. But before I get there, just one more sort of general question. I understand you've been working on this for a while. You're a prolific writer. What did COVID-19 and the resulting exploitation, illustration, use whatever adjective you want, of racial educational inequalities do to this argument? Did it give it steroids? Did it modify it? Did it do anything to it?
Yeah, I think it actually highlighted the exact problem that I was talking about. So in the paper, I use the example of the Detroit school district and the neighboring district, Grosse Pointe, right? Now, these are districts that are mere miles apart, and we saw very different responses to COVID-19 by both districts, mainly because the Detroit district had fewer resources and was not able to respond in many of the ways as the Grosse Pointe district was. The Grosse Pointe district was able to send students home with laptops if they needed it, provide access to hotspots if they needed them, and to continue functioning as best as they could in a COVID world. Whereas the reverse was true in Detroit. Detroit was already a struggling school district, struggling so much that students had sued, arguing that they were being denied of their right to literacy, that they were not being properly educated. COVID-19 hits, and and makes all of these problems worse. And so I think the problem that COVID-19 highlights, that my paper also highlights, is that we have two districts that are both entities of the state, and the state is responsible for providing education to all of its students. Yet the way we subdivide the provision of public education allows Grosse Pointe students to get something more or extra than students in Detroit get, just based on which side of a district boundary line upon which they live. Right, in a more equitable world, in a sane world, we would not have those kinds of boundary lines, and those boundary lines wouldn't dictate who gets access to a laptop or a hotspot and who does not. Instead, the state would distribute all of these resources equally and not allow certain people who can situate themselves between certain boundary lines to monopolize resources while others suffer. So I guess in a nutshell, I would just say COVID-19 has really just underscored my point about the arbitrariness of boundary lines and the ways in which these boundary lines are being used to facilitate exclusion and monopolization by whiter, wealthier districts.
Yeah, yeah. So I don't quote a lot from the paper. I would like people to go out there and do it themselves and do the reading because you put in the work to write it. But one line, I think it was a subtitle or maybe a title from the paper, really stuck out to me. And you just sort of mentioned it, and I want to go there now. And the line that I read, at least in the draft that I read, was school district boundary lines are the new white only signs. School district boundary lines are the new white only signs. Can you talk a little bit more about that analogy? It's a stark one, but I think it's an appropriate one. You want to tell us a little bit more about that?
Yeah, so the reason I went with that analogy is because the boundary lines can now serve effectively the same purpose or same functions as the whites only signs. It does that because the boundary lines, I argue, interact with patterns of historical racial subordination and exclusion to produce race neutral racial exclusion. What do I mean by this? So if you look at the ways in which a place like Grosse Pointe, I keep picking on Grosse Pointe because it's the most stark of these examples. The way a place like Grosse Pointe was constructed to exclude Black people, to either exclude them intentionally at first with racially restrictive covenants or through secondary measures such as higher housing prices, that due to the racial wealth gap, we know many Black people, Latinx people in particular, are not going to be able to afford to locate themselves there. And so rather than holding up a sign that says no Black or brown students allowed in the Grosse Pointe districts, they just draw the boundary line in a way that is going to cut to the heart, that only cut across so that um, the people who live in the district are mainly white, and the people who can afford to live in the district are mainly white, and those who can't are mainly non-white. And I think it's especially pertinent to look at the way also that these boundary lines are enforced. I mean, places like Grosse Pointe actually hire people to private investigators to make sure that the students who are attending the schools actually live within the boundary lines. They have
Wow.
a hotline that you can call if you suspect that someone is illegally using an address to attend a school within the district. And who do you think is going to be more likely to be reported as being suspicious for not living in the district? The anecdotal evidence suggests it's usually Black children. And so I picked on Grosse Pointe a lot, but another example I use in the paper is Jefferson County in Alabama. And so I think that one's relevant too, because Jefferson County is actually still under a school desegregation order, yet
Mhm.
they've still been able to have these mini districts pop up within the county-based district that have exactly the same effect as the boundary lines in Grosse Pointe have. Same deal in Poughkeepsie, New York, which I also use as an example in the paper. So the bottom line is I use the analogy because I think the boundary lines are doing effectively the same work as the Jim Crow laws, but without the explicit race consciousness in doing so.
Yeah, yeah, yeah. I just have Dr. Joshua Glazer's sort of voice in the back of my head. And I think he would be a little disappointed in me if I didn't ask this as a follow-up. Do you think we should have school district boundary lines at all?
Oh, that's a good question. So, I mean, I think you obviously need some way to distribute public education, right? And a completely open, centralized system will have its practical issues. So, I think we do need some mechanisms to make distinctions and cut off. But my issue is the level at which we draw them. In a prior work, I argued that the boundary lines, if they're drawn, should be drawn on a regional level, not on a local level. Why? Because most of us live our lives regionally. Take me, for example. I live in Durham, North Carolina, but I were every morning before the pandemic, I would get in the car and drive across my Durham County boundary line to Orange County to go to Chapel Hill to go to work. Then I would drive back and pick my son up, and sometimes he would go to activities in Cary, North Carolina, which is in Wake County. So I literally live my life regionally, not locally. But the way the laws are set up, it says that schools have to be only at the local level. But we know when you assign schools over a larger territorial base, you have are more likely to have racially integrated schools, more likely to have an equitable share of resources, a larger tax base from which to draw. Obviously, it's not a complete panacea, but some of the most stark forms of exclusion, racial segregation, economic segregation, the combination thereof, occur because of distribution of public schools at the localist of local level. Like with Detroit and Grosse Pointe, there's no reason why you should have districts that are that close together, separated, especially in Grosse Pointe now, as they're seeing population declines, they're having to close schools. Meanwhile, the Detroit schools are suffering. What if we combine those districts and had a larger territorial base? I mean, that might bring other political problems. I'm not naive to recognize that a big part of this is that white parents tend to assiduously avoid schools that are perceived as not good, and schools that are perceived as not good are typically schools with large numbers of students of color. But my main point is the law shouldn't make it easy for parents to fulfill certain associational preferences by allowing such a local distribution of public education.
Yeah. Fascinating, fascinating. So I don't know what you said, but you've definitely struck a chord, and we're getting a lot of questions in the chat and the Q&A function. Please, once again, my audience, please utilize the chat, utilize the Q&A. If you want to send an anonymous direct DM to myself or to Meg Holland. So I'll ask just one more question, and I'll move to Q&A. I want to respect the audience time. I know some of you do have to drop off right at 1. You only had an hour for lunch. Please, if you have a question, put it in the Q&A, and we'll get it answered for you. But so my last question is this. Amongst some of your other colleagues, I know Asmudia James, who says in Miami, wrote a paper called White Like Me, in which he criticized the diversity rationale in higher education. And for the audience that don't know, my students should know, the diversity rationale is the compelling governmental interest that justifies what we call now affirmative action. And she talked about the negatives of the diversity rationale on the identity development of white students. I read your paper, and as a higher ed scholar, I'm thinking, hey, we can use this for higher ed. Is that the case, or is this more limited to K through 12?
I mean, I think some principles definitely cut across beyond K through 12. I mean, the primary contribution, I think, which is the criticism or critique of the way that K through 12 education is disseminated and organized is, yes, definitely more limited to K through 12. But the broader critique of the ways in which white student segregation harms white students and harms the greater democratic processes, I think is applicable beyond K through 12, applicable to higher education, certainly, and applicable to other contexts other than schools. I mean, I talk about the negative problems that occur when you allow white student segregation in schools. You could also argue the same thing is true when you allow white segregation in residential neighborhoods. The messaging that it sends, the insularity, the same issues that occur in terms harms that occur of having predominantly white schools, one could argue happens the same when you have predominantly white neighborhoods, especially in a racially diverse metropolitan area. And so I think Professor James's point, my new colleague, so shout out Professor James, is right on the money in terms of the negative associations, the negative the negativity that could be imparted to the diversity rationale because of that.
Thank you for that, and thank you for indulging my question.